Good afternoon to everybody. My name is Bill Boyce. I'll be your MC for the sessions in this breakout room this afternoon. I'm a former judge in the Court of Appeals, an attorney in private practice now, and a vice chair of the Judicial Commission on Mental Health. This afternoon, the sessions in this room are going to cover the basics of mental health and IDD law. In this session, our panelists are going to share insights from Dallas County's multi-year effort to build a coordinated, countywide 1622 process, including practical strategies, lessons learned, and the value of cross-agency collaboration. Our panelists include retired Municipal Court Judge Rodney Adams, City of Decatur Attorney and Associate Judge Pamela Liston, Dallas County District Attorney's Office Mental Health Division Chief Lee Pierson, and Alyssa Aldrich, the Executive Director of Adapt Community Solutions. Welcome to our panelists.
Good afternoon. Oh, it is so good to be here with you all. I love this summit every year. I told Christy, though, I think this is the best one yet. It has been fantastic. I wondered, how many times can my heart get broken in a single day? That's exactly what needs to happen, though, as we build new ideas and new ways of being. So we're going to talk a lot about 1622 today. And I want to introduce my esteemed panelists. So Judge Rodney Adams is a retired municipal court judge, and he practiced as the presiding judge of Irving Municipal Court for 16 years, and he's a 31-year attorney. Commissioner Lee Pierson is the chief of the Dallas County DA's Office Mental Health Division, and he has been the chief of that division since 2015. He's been a prosecutor for 14 years, and he is also a 31-year attorney. Alyssa Aldrich has a Master of Business Administration and is a fellow of the American College of Healthcare Executives, and she is the Executive Director of Adapt Community Solutions, promoting system transformation, and she and Lee work closely together. I'm Pam Liston. I'm a 30-year attorney, and it was interesting that Judge Adams, Lee Pierson, and I graduated from law school, all we were just discussing, in 1994, so I guess it takes that long to catch on. So what I first want to say by introduction of this topic is how important the 1622 is, and I want from the panelists to understand who we're talking to. So raise your hand if you're from a county with more than 100,000 in population, greater than 100,000. Thank you. Raise your hand if you're from a county with less than 100,000 population. Okay, so we're going to have information for everybody, and these panelists and myself, I'm a retired municipal court judge as well, and as you know, all judges in Texas are magistrates. All of us, by the Code of Criminal Procedure, we're all magistrates. And if you didn't know, municipal judges actually do the lion's share of magistrate work of any level. So while our courts have jurisdiction over Class C misdemeanors only, we magistrate on all levels of offense. So that means our municipal judges need to be well-versed and well-trained. And I know that Judge Adams is a testament to that because he and I worked alongside each other for many years. He was to the far west of Dallas County, I was on the far east. So we were where the east meets the west in the city of Dallas. So I want to start off by having Lee Pierson explain the journey in Dallas County of getting everybody to know about 1622 and how it operates.
Thank you, Judge. The way we started is, I'll move that back. we got together all the involved parties and we started a 1622 committee. And when I say involved parties, I think anywhere you're starting, you want to get everyone who could be involved. The sheriff's office, IT needs to be there, the prosecutor's office, of course the judges, the clerk's office, anyone who's going to be involved. We got together in an advisory committee, and we started before COVID. When COVID hit, that kind of slowed everything down. Then we went virtual for a while, and we had monthly meetings. What are we trying to accomplish? We need to get these reports done. We need to push them out to the parties that are supposed to have them, and we would work the agenda from there. For a long time, we would go a step forward and 3 or 4 steps back, a step forward, 3 or 4 steps back. Because as you start going, we're going to push these forward, the magistrate's office is going to, what's the IT piece for that? Because the amount of reports that we're looking at in Dallas is anywhere from 2,000 to 2,500 reports a month. So we had to have systems created, and in order to do that, we needed all the partners that were there. Alyssa, would you add anything to that?
One of the other parties that we had to make sure was included was the sheriff's department. And everyone was there in a collaborative fashion. Everyone came to the table knowing that, hey, this is our end goal, and what are we going to do to get there? So like he said, I mean, it was several steps backwards, 1 step forward, backwards, forward, but everybody knew that at the end of the day, this is what we want to accomplish, and people were definitely on board for that.
How long did it take you guys from starting those conversations to getting a process in place? How many years?
We think we started the conversations in 2019.
And we started, I know we started the meetings at the end of 2019, and then COVID hit. And from there, meeting monthly with everyone working towards the same goal, it was July of 2023 before we had a soft launch.
Got it. Okay, so 1622, you've been kind of broadly, you've heard that phrase, you've heard that code provision. It comes from the Code of Criminal Procedure. And what it requires is if the magistrate believes through any source really that the defendant, the arrested person in front of him or her has mental illness or IDD or even SUD, they are supposed to make appropriate findings in the bond conditions regarding that accused person. Rodney Adams, can you elaborate on your 1622 experience?
Thank you, Judge. We in Irving, a suburban jurisdiction, when we were wearing the hat of a Dallas County magistrate, we became aware early on about 1622 and how it now had different components in it. Whereas once upon a time, 1622 would give a county jailer up to 72 hours to make note whether someone was presenting themselves with a mental illness or intellectual and developmental disability and notify a magistrate. The revisions to 1622 took that duration down to 12 hours, and it included municipal jailers as well as county jailers. And that perked our ears because we are municipal court judges of reigning Class C misdemeanors, but at the same time, if we're magistrating Dallas County magistrates, we needed to have an ear toward what if someone is having a mental health challenge in custody. So what we had to do is collaborate with our law enforcement and detention staff so that they would be well aware that if they did have someone who presented with that type of behavior in custody, that we had to work out a protocol where they started emailing us 24 hours a day if they had someone booked in and showed that they have that type of behavior, in which case we would respond by creating an order for a mental illness interview, and we were not doing the interview in Irving per se. We didn't have that type of resource at the onset, but we could present that, put that order along with that individual's transfer warrant and packet to send them to Dallas County and give them priority review by Dallas County by virtue of seeing an order. And I might say that the order that we put together to make sure that it was pretty prominent, we put it on lime green paper.
Yes, so Judge Adams figured out a way to make sure his document was seen, and that was to print it on the lime green paper, so when the paperwork went up, they couldn't not notice it. So as you get into this world of doing the 1622 orders and evaluations, and if you kind of look around across the state, you're going to see that municipalities aren't uniform in the way they do it, counties are not uniform in the way that they do it, and different ways of executing this function can still meet the statutory requirements. So Judge Adams has just explained where he would notify the Dallas County magistrates that this person needed a 1622 evaluation. I took a different approach in Rowlett. I read the statute, I found out about the statute. When I was trained as a magistrate, I knew nothing about 1622. I didn't know a lot about several things, including 1715, which is foundational, Code of Criminal Procedure 1715. I didn't really realize that we needed to talk to the defendant before setting a bond amount. Everyone gasped, seriously. Because we have to take their ability to post bond as a circumstance. We have to look at that in setting the bond amount. But the way I was trained and the culture in the North Texas area was it came with a recommended bond amount from law enforcement, and that's what was expected. But we were not meeting the factors of what's required under the Code of Criminal Procedure. I was actually at an unrelated national conference up in Maryland when I got to meet an elderly gentleman lawyer from Houston. Two Texans happened to meet up together, and he found out what I did, and he said, "Oh, tell me about your 1622s." I'm like, "What's 1622?" That's how I found out about 1622. Well, I'm a fast study. When I found out about it, I did better. When I knew better, I did better. And that was about the time frame that O'Donnell versus the city of Houston had come out, or sorry, Harris County, O'Donnell versus Harris County. And we learned a lot about the importance of setting bail and following the statute during that whole long process of that litigation. So I had to meet the law. I had to, regardless of the culture, regardless of what Judge Adams was talking about, the budgetary limitations. And so I found a budget item that was kind of a space keeper, and I started hiring my own mental health evaluator from a neighboring county who did the mental health evaluations to come in and do my 1622s. So I found money, I used that money so that we could meet the requirements of the law. And then we would send them down to Dallas County. So what's interesting to me about Dallas County in particular, and this will resonate with probably everybody in the room, is that they have their own magistrates. Dallas County has magistrates that perform this function in the jail, but they also receive accused people who are coming from the municipalities that have jails. Lee or Alyssa, can you tell us about the challenges that presents?
Well, we don't always know if someone was magistrated and an order was signed at one of the local jails. That information doesn't necessarily come to us. We have a couple of precincts who work with us and who reach out to us directly. But if an order was signed and that individual arrives in the Dallas County Jail, and if that precinct hasn't reached out to us, we may or may not know that an order has been signed. Now, we always hope that the Dallas County magistrate sees that and signs an order on the Dallas County side, or has a suspicion as well as the local magistrate, but there is just a level of trust fall there. And so, yeah.
Okay. And Alyssa, follow up with that on what's the overall process? Okay, so Alyssa facilitates all of this incoming 1622 work. After you get it, what do you do?
Sure. So in all of our developmental conversations and all the backward steps we took and forward steps and back and forth, we eventually were able to get some automation set in place. So right now there's some automation. Whenever the magistrate judge signs an order, it is automatically sent to an electronic medical record system that we have access to. And from there, our staff can see all of the orders that have been signed. Those come in every 15 minutes, or the system is refreshed every 15 minutes, whether or not an order has been signed or not. So they're constantly coming in. So throughout the day, our staff just sees who's next up and they go see them. So we're responding within 24 hours on the weekday. We are not there on Saturdays and Sundays, so there's a little bit of lag on a Monday. And then for individuals who have been released from jail, we also try to get them assessed as well, and we have a process in place where staff is trying to reach them in the community and get that assessment completed via telehealth.
And you have a staff of 20 now.
Now we do. We
Yes.
started much smaller than that.
So what do you do exactly?
Sure. So we have built a lot of relationships, and that's going to be super valuable. So whenever an individual has an order signed, we see that person, we see what location they're in, a clinician is assigned, that clinician goes directly to the jail and assesses them in jail. And we have clearance in order to do that, so you have to go through that whole process. We do have some language services that are in place. So more than 50% of my staff is bilingual in Spanish, which is a huge plus. And if a language other than Spanish is needed, then we have a process for that as well. But initially they present to the jail, request the client from the sheriff's department brings them, we get that assessment completed. It's pretty short and sweet. Honestly, sometimes the assessment length of waiting for a client to be pulled from the cell can sometimes take longer than the actual screening itself. We look at any prior history of the individual that we have. We have worked in collaboration with the county for 10 years now, so we do have a lot of history on some individuals. So we look at anything like that. We inquire about any mental health history that they may have in the system, and some of that information we have access to, and then we generate that report. By the end of a clinician's workday, they will have seen minimum 15 individuals and submitted all of those documentations. Everything's electronic, so when it gets submitted, it is turned around and electronically sent to the magistrate clerk's office instantaneously. And then from there, the magistrate's office emails that out to the defense, to the prosecution, to the sheriff's office, and any other party that legislatively is required to go to. But everything is happening electronically and very rapidly.
And Lee, after that, that email from the magistrate's office, is that where your office, is that where you receive the orders?
Yes, we get we have a DA 1622 email that all of these reports come in to this one email. And the current process, the way we do it is there's an attorney in the mental health division and a clerk in the mental health division, and they upload each one of these as they come in to our tech, we call it Tech Share or ACMS. That's our case management system for the cases for the DA's office. They have to take and manually put that with each case if it's been filed. If it hasn't been filed yet, then they have to go back and put it on a tickler system to go back and check on another day. One of the things we're still working on that we haven't gotten completed yet is automating that process from when we get the email until we can get it attached to the cases. Because as you can imagine, a couple of thousand of these, 2,500 of these reports a month, it's a full-time job, and sometimes they're coming in 20, 30, 40, 100 a day or more, and so they've got to go through and connect them. But that's when we see the reports. But we're trying to get them connected as quick as we can, so then other prosecutors, our case will have a tag, 1622 report, or 1622 not uploaded yet.
And Alyssa, did I hear you right that your staff member will see 15 a day?
Correct.
And about approximately of those, how many of those are recommended that they have some sort of qualifying condition, mental illness, IDD, or substance abuse disorder?
A significant majority, I would say more than 75%.
Okay. All right, good information. Now, those of you from rural locations that are hearing all of what Dallas County is doing, and you are thinking, wow, we don't have any of that, this doesn't apply to us, it does. Because whatever your circumstances are, you make these mechanisms fit in your context. When I started and I learned about this, and I told you I wasn't trained on it, I felt like I was inventing the wheel. This was in 2011. And I actually ended up on the phone with a psychiatrist from Parkland Hospital because I was trying to figure out how this statute operated. And he came and did a mental health evaluation. So you just work with the situation that you have, with the area and your context in order to meet the requirements of the statute. So Judge Adams, why is the 1622 so important in the overall scope of the early detention process?
Well, I'd first like to put into context that coming at it from a suburban municipal court setting, that maybe you've heard, maybe you haven't heard, but one of the statistics that stick with me and has stuck with me since I became a judge 16 years ago was that as far as jurisdictions go, the vast myriad, the constellation of jurisdictions, judicial jurisdictions across the country, one of the statistics is that if there's ever a human being that's going to set foot inside of a courthouse itself or be exposed to some type of court proceeding and whatnot, 80% probability is it's going to be through a municipal court. And if someone finds themselves in custody over a Class C misdemeanor style offense, most likely there might be an attendant offense along with that that's a jailable offense. So there might be a person with possession of marijuana, but at the same time they have public intoxication, or they get charged with possession of controlled substance, but at the same time they had drug paraphernalia. So I'm going to be seeing them on Class C misdemeanor and possibly on a jailable offense and magistrating them. But what an opportunity if you're going to be magistrating that individual, that at that particular, what we call an intercept, if you follow sequential intercept mapping, at that particular intercept, that opportunity to identify someone who may be having an undiagnosed situation or a misdiagnosed situation, or maybe they had a diagnosis and they have abandoned treatment, or for whatever reason they're not being treated anymore, but because of that or tended to that, they may have some type of criminal offense charged as well. Well, if that person gets booked in repeatedly, and some of you would be aware of some of the references that are made to some arrestees, such as their 1088 or their frequent flyer or something along those lines. Well, to see that person recidivating again and again, it's just not a positive outcome or effective outcome to have someone brought into custody, they have a situation that they have untreated, release them only to have them arrested again, attended to the same type situation. So we have an opportunity to delve into what might be going on, and if we look a little bit deeper under the surface as to what the underlying circumstances might be, there's a possibility we could disrupt that activity, and in doing so, promote public safety, promote officer safety, and promote safety of the victim and even the loved ones around those victims who are dealing with them in crisis again and again and again, and it just doesn't seem that arresting them is a solution.
Very, very well said. And so Judge Adams just talked about the intercept model. You've got in your materials the Texas Mental Health and Intellectual and Developmental Disabilities Law Bench Book. And so the tabs are largely the intercept model, the sequential intercept model. And the stage that we are talking about right now is stage 2 of the intercept model, in that early detention where they are in jail on an arrest. So I encourage you to become familiar with the sequential intercept model and what it looks like and how it could apply in your context. Lee and Alyssa, what would you say to our rural colleagues who don't have the number of people, number of professionals, number of people that could attend and do the evaluations, and getting this thing up and going and running and meeting the requirements of the statute?
Sure. I mean, I would say collaboration. It's going to be vital to sit down with all the parties and get on the same page and then start planning from there. It's not going to happen overnight, but I think making those incremental strides to get there will significantly help. And then I would look at telehealth. Because not all of the counties are going to need 19 staff in order to do mental health assessments. But telehealth is a great option, and it's very easily accessible. And yeah, I would start with that.
I would agree with that. I think collaboration in anything that we're discussing in this conference this next couple of days is the key to it all working. Whether it be a 1622 report, diversionary program, getting someone into services. And I can tell you, when we started in Dallas, we haven't always had all the resources that we've had. When I came to the mental health division, there were 2 of us. And many times it was me and my counterpart at the time, Vicki Rice, sitting down and talking. And we haven't had the supportive district attorney that we've had in the past. Our DA now is 1,000% supportive of us. So we've been able to do things and change things, but it wasn't always that way. Alyssa didn't always have 20 people. It used to be me and Alyssa. And we would sit down and go, okay, we've got state of Texas versus whoever. I'm an attorney. I don't know what to do with them. Can you help me? By the way, we've got to call defense. So my thought on that is whenever you've got 2 people together who want to get something done and change the system, you can start talking. Defense and state can talk. Let's go see the judge and see what he or she says. Let's call JSMH. They've got fantastic resources, and let's see if they can give us some guidance. Collaboration is key. I can tell you very truthfully that Alyssa and I have talked on weekends before. We've talked. I called her last night before I went out to meet a friend for dinner, said, do you need me for anything before I get out of here for tomorrow's presentation? It's literally this constant stream of information going back and forth, I think, is what makes what we do in Dallas County as successful as it is. It's by no means is it perfect or even close, but we've got the collaboration part down. We are in constant communication, and anybody can do that.
Now, one thing I will add to that from a clinical perspective is we have said from the very beginning that our clinical assessments are a point in time, and they're also going to be all community-based recommendations. And that's just been an understood. So we are never going to go screen someone or do a full diagnostic assessments on one and say, you need judicial treatment center, you need probation, you need supervision, you need these judicial outcomes. We're not doing that. We're saying if you are released to the community, whenever that may be, here's the community-based treatment plan for you. So we may see someone with a murder charge and we may see someone with criminal trespassing, and both of those may have the same clinical outcome, and the judicial side may be totally different.
Alyssa, give an example of your staff members. What sorts of credentials do they have? Who's doing these evaluations?
Sure. Most of our 1622 screeners are completed by a QMHP, a qualified mental health care professional. And the criteria for that is laid out in the Texas Administrative Code. But the short version is going to be that they need a bachelor's degree in some specified fields. And then they have some mental health training that we give them as well. And they have to do that. Those individuals cannot make a diagnosis on someone. That has to be a licensed clinician. So we do have several licensed clinicians as well. And in the event that our QMHPs feel like there's something more to the story here, I want to get another opinion on this, they'll elevate that up to a licensed clinician, and that licensed clinician will go out and complete a diagnostic assessment.
So the flow and the way this looks, just fundamental pieces, because it will look different depending your own context. But someone gets arrested, they're brought to the jail. They're supposed to be magistrated, no matter what level of charge, within 48 hours. And at that magistration, in front of the judge, which is oftentimes, as I said, a municipal court judge, it's also very often a justice of the peace. It's rarely a higher level district court judge, but certainly all judges are magistrates. It certainly could be. That when they're presented for magistration, maybe the jailer had noticed something and they pass that information on to the judge. Maybe the police officer noticed something and they pass that information on. Maybe the judge, his or herself, notices something about the accused person in front of them, and they have any reason to suspect or believe that there may be an issue that a 1622 evaluation would provide information on, then they make the order for the 1622 evaluation. In this scope that we've been discussing, that's when Alyssa's team gets involved. So then the qualified medical clinician or the licensed clinician gives the report back and makes recommendations to the magistrate. And so those recommendations could look like, well, Alyssa, let me not step on your toes because you'll have the vast scope. What do those recommendations look like?
They're gonna, I mean, it could be anything. I mean, it could be medication management, it could be peer support services, it could be a combination of a psychiatrist and medication management. We're not going to say that you need medicine. We're going to say you need to go here and be evaluated. That's kind of the key difference because, again, my staff, they can't prescribe and they can't diagnose at the QMHP level. So our partners in the community, and I know some of them are here, shout out to MetroCare, then we will definitely recommend a treatment at one of the local providers. So what we try to do is one of the prohibitors in getting access to treatment is access. So we look and see where someone is currently residing at, and we try to get them to the clinic that's closest to them that has the appropriate services. So if they're residing at the homeless shelter, then thankfully in Dallas, our homeless shelter has services there on site. If they're in South Dallas, then we're going to refer them to the clinic that's closest to them down there, and we're not going to send them up to a North Dallas clinic that they realistically may not even be able to get to. Also keeping in mind, what sort of restrictions do we have on transportation and all of those things. So we try to get the best fit for the client that they can maximize their ability to get there and receive services. And then ideally we try to follow up with them in a perfect world and say, are you getting connected? Do you need any assistance? What can we do for you? And then we point them back to their community service provider.
Wonderful. So picking up with the flow, that information comes back to the magistrate, and the magistrate can issue orders that are bond condition orders. So these are conditions of the person being on bond. I've seen those look like reporting to this facility or going to the local mental health authority by such and such time on such and such day. If you're really a working judge, and I hope that you are, you may have staff or you yourself may have already called to figure out availability so that you can put specifics in the order so that you're clear on whether or not the bond condition order has been violated in the future. I had a case once where the recommendation, the evaluator, the mental health expert, gave the recommendation because she discovered in talking to the family and looking up this individual on the system that he had been previously treated at least twice in a community that was about 30 miles away. So her recommendation was what the person be taken to that facility because they were familiar with his case and his particular needs. So those are the sort of recommendations that could be put in such a bond condition order. So Lee, tell me when you pick up the orders that you receive, how does that go?
What we'll do is we use these 1622 reports. The mental health division, we kind of exist to think outside the box on cases. So cases are not directly assigned to the mental health division. Referrals are turned in by defense attorneys. We get some from police agencies. They'll send us information. Judges will reach out to us. But probably 98% of them come in from the defense bar. What we do is we have a referral form that they have to fill out. Why they're coming in, what do you think, what have you noticed? And we have to have confirmation of a mental health diagnosis. The 1622 report is key to that. because that's what 95%, 99% of our referrals have to confirm a diagnosis. I can look at Alyssa's team's report and go, oh, okay, they've got bipolar, they're manic, they've got these things, or there is no diagnosis, and we can move quicker on it. 1622 has allowed us to take our intake time from weeks at a time to just a matter of a few days. We now have someone, she does intake and can get an answer within 4 days to somebody, so that if we're going to help the person, we get that process in place. We reach out to our providers, and what can we do? What's our plan look like? Here's the snapshot on the 1622 report. What can we do to get this person out of jail and get them engaged in services? It also gives us a picture, if it's an assaultive case or has some serious injuries to a complaining witness, we start reaching out to that person, talking to them. Here's what we've got. We may have a mental health issue, so we can get the victims involved in the process from the get-go as well, and use that report to springboard into getting more in-depth information. We reach out to defense attorney. We need additional records so we can see what's going on. Would you get a psychological evaluation or assessment? Would you approach the judge and ask for that? We need to get a risk assessment done so we can see what we can do with this case. But it gives us instant access so that we can look and start trying to get those cases and get people out of jail much quicker than we could in the past.
So why all this work at all? What is 1622 all about? I was surprised to learn that it had actually been a law in Texas statute since 1993. It was already on the books. And then we had the tragic death of Sandra Bland in 2015. And then the legislature got even more serious about making the implementations that were going to serve people that were struggling. And in the very first 2017 legislative act that we refer to as the Sandra Bland Act, you will learn if you dig into that case that she was contacted by law enforcement over a Class C misdemeanor offense. It was a traffic offense. She failed to signal a lane change. And then the contact escalated over whether or not she was going to put her cigarette out while the officer was at her car. And she ended up being taken into custody for, I believe, resisting arrest. And that was on July 10th, 2015. And then she struggled with her mental health while being in custody, and she suicided on July 13th, 2015. So in 2017, we got a more robust version of 1622, and the last few legislative sessions since then, 1622 has been given a very good look. So I mentioned that about the Class C because in that original version, Class Cs weren't limited out of it. Later, we got legislation that said that 1622s would be done for Class Bs and above. Then we got legislation that said it can be done in a Class C misdemeanor, and that's kind of where that issue has rested at this point. But I believe everybody on this panel would cheer loud and clear that yes, this sort of work needs to be done in the overall evaluation of people that may be suffering, because the consequences sometimes are way too great and they way outweigh even the initial law enforcement contact. Judge Adams, in your opinion, taking into consideration the different ways counties and municipalities look, what would a model countywide Article 1622 program consist of?
Well, I'll start out by echoing just what was said earlier about collaboration, because 1622 reads as it does, but we have 254 counties in Texas, and the dynamics of each county is unique in its own right. What we do in Dallas County is unique in its own right because of the number of suburban jurisdictions that are there in the county as opposed to one core jurisdiction where central booking might take place, which would do away with a lot of logistics and whatnot. But we are different in that respect because we have at least 9 different jurisdictions spread out across the county. But in place, whenever I thought about what we could do from the urban Irving's position, I always had an eye toward how could this possibly work, what we're doing in Irving, in Muleshoe or Dime Box or something like that. And the answer is that we have to ask Muleshoe or Dime Box, what is it that your particular dynamics are? And we would have to have a conversation about, in any of these counties, amongst our peers, and even in Dallas County, how I got involved is similar to the way you, Judge, got involved, because, we were exposed to, there's a brand new piece of legislation that we need to pay attention to because of our hats that we wear as magistrates. So in doing my research, I actually wrote a grant to bring sequential intercept mapping planning to our jurisdiction, but we didn't get it. Tarrant County got it instead. But my colleague in Tarrant County, I called and congratulated her, and I said, now can we ride your coattails? And she said, absolutely. So we had an opportunity to start collaborating through Tarrant County, which bounced me back to find peers and stakeholders in Dallas County. And we just started talking and landed on my peers in downtown Dallas County, who are the Dallas County magistrates. I started having working breakfasts with the chief magistrate on an ongoing basis so that we could synchronize our protocol, our procedure, our interpretation of 16.22 with theirs, and make sure that we could make it as a seamless a process as possible, because we were depending on them to get any orders that we have for mental health interviews through them to Alyssa's group, and we would have to let it go, because once we have the handoff, then we would hope that it would go according to Dallas County's protocol. But you start there, and we have to agree, it's not easy. It's not easy at all. But it's worth it. It's so worth it, because the impact that it has on our community, the idea that what we all see, people that are homeless, see people that are self-medicating, and they call it possession of controlled substance. These things can be directly impacted by collaboration with different stakeholders that have different roles to play. But when we combine all these and consolidate them, the outcome is greater than the sum of its parts.
I love the emphasis on collaboration. It may be a judge leading the charge, it may be a prosecutor, it may be a clerk, it may be somebody else in your local environment. You guys know who the doers are. It might be you, or you might be thinking about the other personnel that's really a doer. And so you need these doers, and it doesn't have to look the same way in each location, but you need the doers to lead the charge, to help put it together and involve this collaborative process so that people can be served in this manner. We have very little time left, but I want to know what you have done, any of you, with the resistance you have faced from those that are resistant to this type of process.
Well, I can tell you that first the resistance came from me, because I would look in the mirror and say, we don't have any more time in my jurisdiction, we don't have any more people, we definitely don't have any more money. But 16.22 is the law, and it wasn't put into law. As you gave a wonderful backdrop to the Sandra Bland Act, what a tragedy. And I just, I made a deal with myself. I said, if I had a tragedy like that occurred in my jurisdiction, I'd probably resign, because I just couldn't deal with it. So I said, well, I don't want to resign, and I don't want anybody to get injured, so I'm going to find a way to make this work, and not just give it lip service, but to bring enough people together to the place where if we all do what we do best in our own respective missions, this will work and it will be effective. It's not perfect, but it will. So when people tell me we don't have the time and the money, I said, yeah, that's where I started. And I gave myself a very low probability of success. That's where I started. But as we have grown and matured in this process, we find that some of the results that we have are nothing short of miraculous. And you've got to believe, if you're in law enforcement and you stop seeing that usual person that used to hang out at the beer and wine or whatever, they're not there anymore. It's not that they moved on, it's they got their feet down, they got stabilized. We found out, and I'll tell you in those certain terms, some of the people that I've come in contact with under these circumstances, I see them again, I have to reintroduce myself because I can't identify them. They're really great people. They just were in some tough circumstances, and that means that going forward, that's one less individual that we have to spend so much time in services, law enforcement services on, and we can start to focus on the next individual who comes along to help them as well.
Perfect final word. Let's give a hand to these panelists.